Hello, everyone. Welcome to today's immigration chat. I am attorney Ebony Anuforo. I'm an immigration attorney located in New Jersey, representing clients in all 50 states and around the world with immigration law matters. Today, I have a great topic for us to talk about. This is a common question that comes up, and it is, what are common reasons why your VAWA application is denied? If this is your first time joining me, and you do not know what VAWA is, well, VAWA stands for Violence Against Women Act. And although the term woman is in its name and its title, it is also for men, not just women. And this benefit provides an avenue for certain victims of domestic violence and abuse to apply for a green card on their own. So if you are the spouse or ex-spouse of a U.S. citizen or a resident, if you are the child of a U.S. citizen or resident, or if you are even the parent of a U.S. citizen who is 21 years or older and you're being abused either physically or emotionally or in any other extremely cruel way, then you may be able to apply for your green card on your own without your petitioner. This benefit is truly a self-petition. So, what are some of the reasons that your application might be denied? Well, first, if you're applying for VAWA based on an abusive marriage, then you are still responsible for providing evidence of a bona fide marriage. So this means that you have to provide evidence that your marriage was real, evidence that you live together, joint finances, bank statements, joint children if you have any, statements from family, statements from friends, pictures, any credible evidence that shows that your marriage was based on love and that you did not get married to secure immigration benefits. Now, if you're unable to do that, then you run the risk of having your VAWA application denied. A marriage certificate and a few pictures at your wedding is not enough for you to prove that you had a bona fide marriage. USCIS is going to want to see more evidence, especially evidence concerning commingling of finances, right? That's a big one for them. Now, there are some cases when the abuse or the abusive situation makes it difficult for the self-petitioner to get these documents or to have proof. However, there might be other ways that you can show that you were in fact married, right? Including your personal statement and statement of others. You have to think out the box in situations like this, So when we have situations like this, we try to get really creative to show proof. I mean, we don't create any evidence, right? But we try to think of other ways that we can provide evidence to show proof that the marriage was real. So if you're having a difficult time, I really encourage that you work with an experienced immigration attorney to assist you with your VAWA case. Now, another reason why your VAWA application could be denied is that you did not provide sufficient evidence of the abuse or extreme cruelty. Now, the whole purpose of the VAWA petition is to provide an avenue for victims to self-apply for their green card. The government's thought process was that if victims had an avenue to get a green card on their own, they might be less likely to stay in abusive and dangerous situations just because of their lack of status. So you, as the VAWA self-petitioner, you bear the burden of proof to show to USCIS that you were abused. Now, I get a lot of questions about whether a police report is required or necessary in order to apply for a VAWA self-petition, and the answer is no. A police report is not required. While it's very strong evidence, if you have one, abuse under VAWA can come under many different forms, including physical abuse, emotional, financial, sexual, and other behaviors that lead to extreme cruelty. So it's very important when you are applying for a VAWA self-petition that you provide evidence of your abuse. Another reason why someone might be denied for their VAWA application is that they missed the filing deadline. So what do I mean by this? Technically, you can apply for VAWA at any point after your abuse. However, if you are divorced from your abusive spouse and you're basing your VAWA petition on that marriage, you have up until 2 years after your divorce became final. So if you were divorced because your spouse was being abusive and you left and you're just learning about this benefit, then you might want to consider your timeline, your time frame to apply. So again, remember that you have 2 years from when your divorce became final to apply. Another reason why people get denied on their VAWA application is for mistakes on the application. It is very important that you work with an immigration attorney who is experienced with this type of case. And most importantly, try not to DIY. Some people do get lucky and they're able to get to do it on their own and they're able to get their VAWA application approved. However, if you have very complicated set of facts in your case or you have a very complicated immigration history, then you may not want to risk applying for VAWA on your own, and you may not want to risk making mistakes on your application and therefore getting a denial. A denial will lead to time wasted, money wasted, and also just the emotional stress of having your VAWA application denied. So if you're thinking of applying for VAWA, consider working with an immigration attorney in order for you to lower the risk of getting a denial on your application. Another reason why someone might get their VAWA application denied is that they did not provide evidence that they lived with their abuser, their spouse. So one of the requirements for VAWA is that you lived with your abuser at some point, even if it was for a short period of time. Failure to provide evidence that you lived together could lead to you receiving a denial. Again, you have to provide either a copy of your joint lease agreement, evidence that you both shared bills going to the same address, a mortgage statement. If you don't have that, maybe you can submit statements from family or friends who know that you both live together and so forth. But you have to be able to provide evidence that you lived with your abuser at some point. Another reason why you could be denied on your VAWA application is that your declaration was not strong. Now, one of the most important pieces of evidence that you will submit with your VAWA application is your declaration, which is essentially your personal statement. This is your opportunity to share facts and details about the abuse. You can also use this opportunity to talk about your relationship, how it started, how it ended, if it ended, how the abuse happened, what happened, how it affected you. If you do not provide an effective VAWA declaration, one that is compelling, one that is credible, you could be denied. So this is where working with an immigration attorney comes in and handy and is very important, because an immigration attorney will be able to guide you and advise you on whether your declaration is effective and strong for your VAWA application. There are certain key factors and key details that USCIS will be looking at when they are reviewing your VAWA application and when they are reviewing your declaration. So it's very important that you write a very strong declaration when submitting your VAWA application. And another reason why your VAWA application might be denied is because you got married while your application was pending. If you are applying for VAWA based on abuse from your spouse, who you have since divorced, then you cannot get remarried. You cannot get remarried while your application is pending. You can get remarried after you get your approval. Getting married while your application is pending will render your application null and void, and you will be denied. Now, this does not mean that you have to stay single while your application is pending. No, that's not what I'm saying. It simply means that you cannot get remarried because you're basing this VAWA application on that previous marriage. Okay, so this is something you want to consider if you are thinking of applying for VAWA based on a divorce from an abusive spouse. Now, the examples that I listed are not the only reasons why your VAWA application could be denied. There could be many different reasons that you could receive a denial, but these are some of the main examples why some people have received denials on their VAWA application. I hope that you found today's chat helpful. Please continue to send your questions, and I will be happy to answer them in a chat or in a video or even a webinar. If you would like access to our newly formed Facebook group, you should join us. We provide daily immigration tips. We answer frequently asked immigration questions. We host weekly webinars, and we answer your direct questions via chat. you can go ahead and click the link in the bio to join. It's completely free. And every week we will be selecting 2 individuals from our Facebook group to win a free case evaluation for either themselves or for a loved one. If you have an immigration case that you would like us to help you with, then you can also give our office a call. Our number is 201-565-0099. We are located in New Jersey. However, we represent clients in all 50 states and around the world with immigration law matters. Again, my name is Attorney Ebony Anuforo. Thank you for tuning in.